In a federal courtroom, two visions of the future are colliding. Caterpillar, the century-old titan of construction equipment, has filed suit against blue light machines, a technology upstart barely a decade old. The dispute centers on something that didn't exist when Caterpillar was founded: autonomous construction vehicles that operate without human control. At stake is more than market share. The case threatens to answer a question the construction industry has avoided for years: when a machine makes its own decisions, who owns the liability? Caterpillar Incorporated built its empire on steel and diesel. Founded in 1925, the company's yellow machines reshaped landscapes across 6 continents. By the time software became standard in construction equipment, Caterpillar had already invested billions in proprietary systems. According to company filings, Caterpillar holds over 2,000 patents related to equipment automation and control systems. The company's legal team argues that these patents form a protective wall around technologies it spent decades developing. But patents are only valuable if they can be defended. Blue light machines emerged from Silicon Valley's autonomous vehicle boom. Founded in 2014, the company approached construction from a software-first perspective. Where Caterpillar retrofitted existing machines with digital controls, Blue Light designed autonomous systems from the ground up. The company's pitch to construction firms was simple: rent our AI operators, not just our equipment. According to court documents, Blue Light's technology allows multiple machines to coordinate without human intervention, optimizing workflows in real time. Caterpillar noticed, and Caterpillar filed suit. The lawsuit centers on 3 specific patent claims. First, a system for real-time obstacle detection and autonomous path adjustment. Second, a method for coordinating multiple autonomous machines on a single job site. Third, a liability logging system that records every machine decision for post-incident analysis. Caterpillar alleges that Blue Light's core platform infringes on all 3 patents. According to the complaint filed in federal court, Caterpillar engineers developed these systems between 2010 and 2015, securing patents in 2016 and 2017. Blue Light's commercial launch came in 2018. The timeline, Caterpillar argues, speaks for itself. In legal filings, Caterpillar's position is unambiguous. The company claims it invested over $500 million in autonomous equipment research before Blue Light existed. Court documents detail a timeline of development: early prototypes in 2011, field tests in 2013, patent applications in 2015. Caterpillar's attorneys argue that Blue Light hired away key engineers who had worked on these exact systems. The complaint cites internal emails and technical specifications that allegedly show Blue Light replicating Caterpillar's patented approaches. The company is seeking both an injunction to halt Blue Light sales and damages for lost revenue. Blue Light's response challenges every premise. According to the company's counterclaim, Caterpillar's patents describe industry-standard approaches that were already public knowledge when filed. Blue Light argues that obstacle detection using LiDAR and camera arrays was widely published in academic literature years before Caterpillar's patents. The company points to research from MIT, Stanford, and Carnegie Mellon dating back to 2008. Regarding the coordination patent, Blue Light contends that similar systems were demonstrated at construction trade shows as early as 2012. Their engineers, Blue Light maintains, developed their platform independently using publicly available techniques. Beneath the patent dispute lies a more fundamental conflict. Traditional construction equipment is operator-controlled, liability flows clearly from human decisions. Autonomous machines complicate this. If a self-driving excavator damages property or injures a worker, who bears responsibility? The manufacturer who built it? The software company that programmed it? The contractor who deployed it? Neither Caterpillar nor Blue Light has been willing to fully embrace liability for autonomous decisions. Industry observers note that this lawsuit may force both companies to take positions they've avoided. The court's ruling could establish precedents that define responsibility for an entire generation of AI-powered equipment. The construction industry is watching closely. If Caterpillar prevails, it could consolidate control over autonomous construction technology, potentially slowing innovation and raising costs. If Blue Light wins, the floodgates may open for competitors to develop similar systems without fear of patent challenges. Trade associations have filed amicus briefs on both sides. Equipment manufacturers support Caterpillar's right to protect its investments. Technology companies and contractors warn that overly broad patents could stifle the very automation the industry needs to address labor shortages and productivity challenges. A trial date has been set for late 2024. As both sides prepare for trial, the broader questions remain unanswered. Can a century-old manufacturer adapt to a software-driven future while protecting its legacy investments? Can a startup disrupt an industry without running afoul of existing intellectual property? And most critically, as machines gain autonomy, how will society assign accountability when something goes wrong? The Caterpillar versus Blue Light case won't resolve all these questions. But it will determine who gets to ask them, who profits from the answers, and whether the future of autonomous construction will be built on open innovation or controlled by those who got there first. The machines are ready. The law is still catching up.